As I hear petitioner, the argument is that, of course, we are delegated this authority to hire the technicians and to supervise them. But that does not convert us into an agency for the purposes of the relevant statute. How do you respond to that?
So the term agency in the statute includes and requires compliance by components and entities that are designated to act on behalf of that agency, and that includes subcomponents within a federal agency, and that's the thing that petitioners are most analogous to in this system that Section 709D and Section 709E have set forward. It's hard to imagine how someone can fully employ federal employees from the perspective of their being able to hire, fire, and supervise federal employees' day-to-day employment activities without holding that they are, in fact, acting as a component of an agency that's required to bargain.
Well, there's always delegations from the head of agencies to subparts, but those, the delegees are not converted to agencies. They may be agents for a limited purpose. They may have limited authority that's delegated from the top, but they're not converted to an agency. And I think that's the leap that I'm having some difficulty with.
So I think it would be helpful if I could maybe go through a few sets of provisions in the Federal Service Labor Management Relations Act that do indicate that the actual bargaining requirement often lies with a component of a federal agency, which I think helps bridge that gap to then seeing that petitioners are like that component. So the first set of provisions are the definition of collective bargaining and the definition of appropriate unit. Those are on page 3A and 5A of our statutory appendix. And those indicate that bargaining is often done not on a high-level agency basis, but on an agency, plant, installation, functional, or other basis. Now, the second set of statutory provisions that I think is helpful are the exclusions from the definition of agency. Those are on page 3A of the statutory appendix, and that excludes entities like the FBI and the Secret Service. And if we were to accept this proposition that only the high-level agency is required to comply with the Act and collectively bargain, there would have been no need for Congress to exclude the FBI and the Secret Service, because they aren't high-level agencies. The FBI is part of DOJ, the Secret Service is part of the Department of Homeland Security.